Fuller, Gaines, Galgiani, Glazer, Hall, Hancock, Hernandez, Hertzberg, Hill, Hueso, Huff, Jackson, Lada, Leno, Leyva, Liu, McGuire, Mendoza, Mitchell, Monning, Morlock, Morrell, Wynn, Nielsen, Pan, Pavley, Roth, Runner, Stone, Vidak, Bykowski, Wolk.
A quorum is present. Would the members and our guests beyond the rail and in the gallery please rise? We will be led in prayer this morning by our lovely chaplain, Sister Michelle Gorman, after which please remain standing. We will be led in the Pledge of Allegiance to the flag by our colleague from the great Silicon Valley, Senator Jim Bell.
Let us center ourselves in God's presence. God of mystery and wonder, the multiplicity of galaxies and stars make possible our living and dying. We are connected to everything on this planet as we share atoms, oxygen, and carbon dioxide. We rejoice in our human capacity to wonder, to seek meaning and purpose, to rejoice and to give thanks. We benefit from the insights and teachings of all who have walked this path of life before us. May we grow in respect and appreciation for the diversity and beauty of all that lives this day, as we seek to explore the mystery of our being in freedom and safety. Amen.
Of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Members, we're going to move to privileges of the floor. We don't have any registered today, so just want to make sure if we, nope. Very well then, and we will move to messages from the governor. Messages from the governor will be deemed read. Messages from the assembly will be deemed read. Reports and committee will be deemed read and amendments adopted. Motions, resolutions, and notices, members. Pursuant to Senate Rule 29.10, the following bills are referred to the Rules Committee. Item 107, SB 539. Members, we're going to move to a consideration of the daily file, beginning with our second reading file. Secretary, please read.
Senate Joint Resolution 18 with amendments, Senate Bill 681, Assembly Bill 453, 15 with amendments, 142 with amendments, 446 with amendments, 692 with amendments, 693 with amendments.
Second reading file will be deemed read. Members, we're moving to governor's appointments. Don't see the pro tem. Members, we're going to move to Assembly third reading, so be ready. Again, members, we're moving to Assembly third reading first today, and we are going to provide you a couple of the items so you know what's coming up. The order is as follows: item 125, 143, 149, 150, and 152, members. We're going to begin with file item 125. Senator Wajkowski, not at his desk. File item 143. Senator Jackson, are you prepared to take up this item? We'll pass on file. File item 149. Senator Wolk. We'll pass on file. File item 150, Senator Pan, not at his desk. File item 152, Senator Allen. Pass on file. Members, the next items we're taking up is 153, 154, 161, 162, and 168. Moving on to file item 154, Senator Liu. Pass? Pass on file. File item 161. Senator Leyva, not at her desk. File item 162. Senator Wesso. 168. Senator Leno. Pass. Members, we're moving back to file item 156.
Let's get going.
Secretary, please read.
Assembly Bill 964 by Assemblymember Chow and acroling to civil law.
Mr.
Senator
President,
Jackson.
Thank you, Mr. President and Senators. 2014 was a record-setting year, sadly, for not a very good thing, the number of security breaches that were reported. According to a January 2015 report by the California Attorney General's Office, 187 breaches were reported to the California Department of Justice in 2014, compared to 167 in 2013 and 131 in 2012. Under current law, if the personal information that was stolen was encrypted, businesses and agencies are not required to give notice. This provision serves to encourage businesses and agencies who store personal information to adopt encryption so that if information is stolen, that information would be deemed less vulnerable to abuse. However, encryption is not clearly defined in statute. Assembly Bill 964 defines, for purposes of the existing data breach notification requirements for businesses and public agencies, the term encrypted to mean rendered unusable, unreadable, or indecipherable to an unauthorized person through a security technology or methodology generally accepted in the field of information security. With that, I respectfully ask for your aye vote.
Members, debate or discussion on this item? Debate or discussion? Senator Stone.
Thank you, Mr. President. Good morning, members. I stand opposed to AB 964, and that the author and no one else has offered a reason for the existence of this seemingly nothing bill. To what end is the definition of encrypted supposed to be put into statute? If it does nothing sufficiently well, then why does it exist? For those reasons, I stand opposed.
Members, additional debate or discussion on this item? Seeing and hearing none, Senator Jackson, would you like to close?
Yes, I'll read again what Assembly Bill 964 does. It defines what encryption means for purposes of the existing data breach notification requirement. There has been confusion, and there hasn't been a definition. This bill creates that definition so that businesses and public organizations know what their responsibilities are if, in fact, a data breach occurs. With that, I would ask for your aye vote.
Secretary, please call the roll.
Allen. Aye. Anderson. No. Bates. No. Bell. Aye. Berryhill. Block. Aye. Cannella. Aye. De Leon. Fuller. Gaines. No. Galgiani. Glazer. Aye. Hall. Aye. Hancock. Aye. Hernandez. Hertzberg. Hill. Aye. Weso. Aye. Huff. No. Jackson. Aye. Lada. Aye. Leno. Aye. Leyva. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. No. Morrell. No. Wynn. Nielsen. No. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. No. Stone. No. Vidak. No. Wykowski. Wolk. Wolk, aye.
Please call the absent members.
Berryhill. De Leon. Fuller. Galgiani. Hernandez. Aye. Hertzberg. Galgiani, aye. Leyva? Aye. Wynn? Aye. Wachowski?
Ayes 25, noes 10, the measure passes. Members, we're going to move back to file item 172, pass on file. File item 174, Senator Block. Pass on file. File item 175, Senator Jackson, on her desk. File item 179, Senator Mendoza. Pass on file. File item 191, Senator Hall. Pass on file. File item 193, Senator Jackson. Secretary, please read.
Assembly Bill 494 by Assemblymember Mainshine, an act relating to civil procedure.
Senator Jackson.
Thank you, Mr. President and colleagues. Animal abuse is often correlated with family violence, and many people who abuse their family members or intimidate partners also threaten, injure, and kill their victims' pets as ways to intensify their abusive habits. In 1993, the legislature passed the Domestic Violence Prevention Act, taking great strides to help victims free themselves from abusive relationships and to stay protected. The act was then amended in 2007 to allow for a victim in an abusive situation to file for a restraining order against the abuser that also protects the victim's pets and companion animals. AB 494 seeks to bring other sections of state law in line with the Domestic Violence Prevention Act by allowing 3 types of restraining orders to apply to both the person seeking the restraining order and their companion animals, should the adjudicating officer find it necessary and appropriate. Expanding the protections already provided under domestic violence restraining orders will permit victims of child abuse, sexual assault, stalking, and elder abuse to be able to better protect themselves and their pets when they are filing for these restraining orders. The bill passed out of the Senate Judiciary Committee with unanimous support, and I would respectfully request your aye vote.
Members, debate or discussion on this item? Debate or discussion? Seeing and hearing none, Secretary, please call the roll.
Allen? Aye. Anderson? Aye. Bates? Aye. Bell? Aye. Berryhill? Aye. Block? Aye. Canella? Aye. De Leon? Fuller? Gaines? Galgiani? Aye. Glazer? Aye. Hall? Aye. Hancock? Aye. Hernandez? Aye. Hertzberg? Hill? Aye. Hueso? Aye. Huff? Jackson? Aye. Lada? Aye. Leno? Aye. Leyva? Aye. Liu? Aye. McGuire? Aye. Mendoza? Aye. Mitchell? Aye. Monning? Aye. Morlock? Aye. Morrell? Aye. Wynn? Nilsson? No. Pan? Aye. Pavley? Aye. Roth? Aye. Runner? Aye. Stone? Fidak? Aye. Wachowski? Wolk? Wolk, aye. Nielsen, note aye.
Please call the absent members.
Gaines, aye. De Leon? Fuller? Hertzberg? Huff? Aye. Wynn? Aye. Stone? Aye. Wachowski?
Ayes 36, no 0, the measure passes. Moving on to file item 194, Senator Pavley. Pass on file. Members, we're going to take up file item 200, 201, 202, 203, 204, and 205. So moving right along with file item 200, Senator Hill. Pass on file. File item 201, Senator Leno. Pass on file. File item 202, Senator Hill, pass. File item 203, Senator Roth. Secretary, please read.
Assembly Bill 1072 by Assemblymember Daley and Act relating to insurance.
Senator Roth.
Thank you, Mr. President. Colleagues, police, firefighter, and other public safety benefit associations provide aid and assistance to their members and their dependents through products that are very similar to long-term disability and long-term care benefits, usually provided by insurance companies. Unlike insurance companies, however, these associations are not regulated by the Department of Insurance. Assembly Bill 1072 simply requires these associations to provide the Department of Insurance a one-time opinion by a qualified actuary that shows the association's reserves and related practices are actuarially sound and that they will be able to pay promised benefits. It's sponsored by the CCPOA, firefighters, and police officer associations, and is supported by public safety associations across the state. It has no opposition and has had no votes. I respectfully ask for your aye vote.
Members, debate or discussion on this item? Debate or discussion? Seeing and hearing none, Secretary, please call the roll.
Allen. Aye. Anderson. Aye. Bates. Aye. Bell. Aye. Berryhill. Aye. Block. Aye. Canella. Aye. De Leon. Fuller. Gaines. Galgiani. Aye. Glazer. Aye. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Hill. Aye. Hueso. Aye. Huff. Aye. Jackson. Aye. Lada. Aye. Leno. Aye. Leva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. Aye. Morrell. Aye. Wynn. Aye. Nielsen. Aye. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. Aye. Stone. Aye. Vidak. Aye. Wachowski. Wolk. Wolk, aye.
Please call the absent members.
De Leon. Fuller. Gaines. Hertzberg. Wachowski.
Ayes 35, no zero. The measure passes. Moving on to file item 204, Senator Galgiani. Pass on file. File item 205, Senator Hueso. Pass. File item 206, Senator Hernandez. Secretary, please read.
Assembly Bill 145 by Assemblymember Gomez, an act relating to private employment and declaring the urge thereof to take effect immediately.
Senator Hernandez.
Thank you, Mr. President. Members, this bill, specifically this bill would change the definition of an employer to be an individual or organization that employs more than 100 beneficiaries of the Medi-Cal program. The 100-person threshold was arrived by an agreement between the AFL-CIO, CMTA, and the Chamber of Commerce. Unfortunately, there was a late session drafting error that was filed to amend the reference to a prior version of the bill that contained a 50-employee threshold because this bill was already signed into law last year. And this bill simply corrects that error and fulfills the commitment made to the business community. There is no opposition, and members, I respectfully ask for an aye vote.
Members, debate or discussion on this item? Debate or discussion? Seeing and hearing none, Secretary, please call the roll.
Allen. Aye. Anderson. Bates. Aye. Bell. Aye. Berryhill. Aye. Block. Aye. Canella. Aye. De Leon. Fuller. Gaines. Galgiani. Aye. Glazer. Aye. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Hill. Aye. Hueso. Aye. Huff. Aye. Jackson. Aye. Lada. Aye. Leno. Aye. Leva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. Aye. Morrell. Aye. Wynn. Aye. Nielsen. Aye. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. Aye. Stone. Aye. Vidak. Aye. Wachowski. Wolk. Wolk, aye.
Call the absent members.
Anderson. Aye. De Leon. Fuller. Gaines. Aye. Hertzberg. Wachowski.
Ayes 36, no zero on the urgency. Ayes 36, no zero on the measure. The measure passes. Moving on to file item. Oh, sorry. Senator Jackson, for what purpose do you rise?
Yes, under motions and resolutions, my apologies. I would like to move to reconsider file item 156, AB 964 for chaptering issues.
Okay. Without objection, reconsideration is granted.
Thank you.
Ayes 37, no 0.
Thank you, Mr. President.
Thank you. Senator Nielsen, for what purpose do you rise?
Mr. Chairman, are we still on motion to resolutions for a moment?
Correct.
Motion to resolution, a request on behalf of Assemblymember Irwin that number 352, AB 171, be moved to the inactive file at the request of the author.
Without objection. Members, we're moving back to file item 207. Senator Hancock, are you prepared? Secretary, please read.
Assembly Bill 1081 by Assemblymember Quirk, an act relating to civil actions.
Senator Hancock.
Thank you, Mr. President and members. AB 1081 changes the way that temporary civil restraining orders are extended to eliminate a potential gap in protection. Now, when a hearing extension is requested, the requesting party sometimes isn't aware they also have to ask the court to reissue the temporary restraining order and can be left without protection. AB 1081 allows temporary restraining orders to remain in place until the hearing takes place. It has received unanimous support in both houses, and I would ask for your aye vote.
Members, debate or discussion on this item? Debate or discussion? Seeing and hearing none, Secretary, please call the roll.
Allen. Aye. Anderson. Aye. Bates. Aye. Bell. Aye. Berryhill. Aye. Block. Aye. Canella. Aye. De Leon. Fuller. Gaines. Galgiani. Aye. Glazer. Aye. Hall. Aye. Hancock. Aye. Hernandez. Aye. Hertzberg. Aye. Hill. Aye. Weso. Aye. Huff. Aye. Jackson. Aye. Lada. Aye. Leno. Aye. Leyva. Aye. Liu. Aye. McGuire. Aye. Mendoza. Aye. Mitchell. Aye. Monning. Aye. Morlock. Aye. Morrell. Aye. Wynn. Aye. Nielsen. Aye. Pan. Aye. Pavley. Aye. Roth. Aye. Runner. Aye. Stone. Aye. Vidak. Aye. Wachowski. Aye. Wolk. Wolk, aye. Fuller, aye.
Call the absent members.
De Leon. Gaines. Aye. Mr.
Ayes 39, no 0. The measure passes. Moving on to members, the next couple items we have are 215, 217, 218, 219, and 220. Moving on to file item 215. Senator Hill, pass on file. File item 217, Senator Jackson, pass on file. File item 218, Senator Mitchell, pass. File item 219, Senator Morrell. Secretary, please read.
Assembly Bill 728 by Assemblymember Hadley, an act relating to state government.
Senator Morrell.
Thank you, Mr. President, and thank you, members. Assembly Bill 728 by Assemblyman David Hadley is a measure to increase government transparency by requiring state agencies to publish completed accessible audits on their existing websites. I respectfully ask for your aye vote. Thank you.
Members, debate or discussion on this item? Debate or discussion? Is there objection to using a unanimous roll call? Seeing and hearing none, ayes 39, no 0. The measure passes. Moving on to file item 220. Senator Hill. Secretary, please read.
Assembly Bill 599 by Assemblymember Bonilla, an act relating to clinical laboratories.
Senator Hill.
Thank you, Mr. President. AB 599 updates the scope of practice of cytotechnologists to reflect the technology advances that have occurred since they were first licensed more than 20 years ago. Cytotechnologists are professionals who work in laboratory settings. They work under the direct on-site supervision of a laboratory director who is responsible for ensuring they have the proper competency, training, and experience to perform all testing. AB 599 updates statute to allow cytotechnologists to perform tests with new technologies which are within their training, hopefully causing more cytotechnologists to stay in-state, less labs to ship specimens out of state, and creating high-skilled jobs. The bill has received no votes. I ask for your support.
Members, debate or discussion on this item? Debate or discussion? Seeing and hearing none, is there any objection to using our unanimous roll call? Seeing and hearing none, ayes 39, no zero, the measure passes. Moving on to file item 222, Senator Mitchell. Senator Mitchell? Pass. Secretary, please read.
Assembly Bill 1017 by Assemblymember Campos, an act relating to employers.
Senator Mitchell.
Thank you very much, Mr. President. I'm pleased to present AB 1017, a bill that would help create a more unbiased structure for negotiating pay and to ensure that women are not tied to private salaries that may have been discriminatory. Just a little background on what the challenge is. According to a recent report from the Institute for Women's Policy Research, the gender wage gap in California will not close until the year 2042 if progress continues at its snail's pace. This slow rate of progress is due at least in part because we have allowed employers to base salary decisions during the hiring process on prior salaries that we know reflect historical inequities. Since changing jobs is often the best opportunity women have to increase their pay, it's imperative that women are not penalized by their prior salaries. The impact of prior salaries is particularly concerning in certain industries and across racial lines. Example, women in Silicon Valley with advanced degrees are making more than 70% less than men with the same degrees. And as we heard yesterday on a bill on pay equity, we here in this state experience some of the largest wage gaps for women of color, African American and Hispanic women who make just 64 cents and 44 cents respectively for every dollar a white male earns. These depressed salaries only serve to devalue a woman's worth and make it harder for her to negotiate better pay. In some cases, employers won't even consider applicants who are not within a certain percentage of their target salary range, leaving those who've been discriminated against completely left out of the applicant pool. Alternatively, the lower prior salary allows subsequent employers to drive down the bargain during salary negotiations. What this bill is attempting to accomplish, it will prevent employers from perpetuating unfair wage differentials by requiring salary decisions to be based on qualifications, experience, and expertise as opposed to prior salary levels. The vast majority of businesses have accurate wage information on what the current market is for potential job positions. According to a study by payscale.com, 85% of employers use salary ranges to structure compensation programs based on online salary data, salary surveys, etc. Additionally, nothing in this bill prevents a worker from volunteering to offer her prior salary if the prior salary could benefit the worker in her negotiations. This bill does not specifically exclude public employers. Rather, this bill excludes salary information that is already publicly disclosable pursuant to state or federal law. This also includes the legislature. There is no way to restrict access to that kind of salary information, and we know that public salary information is helpful for workers to know how their salaries compare to others doing similar work. By creating a more unbiased structure for negotiating pay during the hiring process, AB 1017 will help empower women to negotiate a fair salary and hopefully get us closer to achieving pay equity in California. I respectfully ask for your aye vote.
Members, a better discussion on this item. Senator Stone.
Thank you, Mr. President, and I was very happy yesterday to vote with a unanimous vote to make sure that we pay women equally as we do men, not only in this institution but throughout the state. But it's interesting that if we hire staff in the Senate, we can only pay them 10% more than they made in their prior job. I think we need to set the example for the state by changing our own rules here in the Senate. But I also want to speak as an employer. As an employer, I like to know prior histories of salaries so that I can make sure that I'm paying people scale, that I'm paying people fairly, that I'm paying people equally. But this bill is just another one of many attempts to inappropriately and unnecessarily interfere with the relationship between employers and job applicants. Salary history information is a non-discriminatory tool that benefits both employers and job applicants. Employers may not always have accurate wage information on what the current market is for all potential job positions to properly compensate employees. There must be 10,000 different job descriptions in the state of California. There isn't an index that you can look up to see what prevailing wages are. It also allows business competitors to lure talented employees from their workforce. There are already many laws that protect employee discrimination. The Federal Equal Pay Act also precludes employers from paying a different wage for the same job based on gender, which we codified unanimously yesterday. The Fair Employment and Housing Act and Title VII preclude an employer from discriminating against an employee, including wages based on gender. With all these laws in place to protect employees from gender discrimination, we do not need another opportunity for litigation against employers in the state of California. Please, I rise to urge you to vote no on this measure. Thank you.
Thank you. Senator Bates.
Thank you, Mr. President. I'd just like to underscore what the fine senator from Riverside had to say. May I read? Would like to read just a
Without objection.
Paragraph from our compensation policy. It is Senate Rules Committee policy when hiring new employees to allow for no more than a 5% increase above their current and prior salary. I am very, very supportive of the equal pay that we voted the other day. My mother was a victim of doing the same job for lesser pay than a male colleague in the same department. So we've corrected that. We need to correct our Senate policies, and we need to do that immediately before we move forward with something like this. The double standard, I think, does not reflect well on us following the rules that we place on those that we serve. I urge a no vote.
Senator Leyva.
Thank you, Mr. President. Members, I stand in strong support of this bill. You're either qualified for a job or you're not qualified for a job. That is what your pay should be based on. If we don't pass this law, and yes, there are already many, many laws that are supposed to protect workers, but they don't. If we don't pass this law, then we will perpetuate the cycle. This is a way to end and break the cycle of women being paid less than men. Yes, we passed a great law yesterday, equal pay for equal work. Well, let's see how it works going forward. We have decades of work to make up for. This bill will help with that. As far as what we need to do on our own house here, I would just say to my colleagues who have brought it up many times, we're working on it in Senate rules. And when we have a finished product for you, we will bring it before you. I urge an aye vote.
Senator Allen.
Thank you very much. I have been thinking a lot about this bill, and I think that, one of the reasons why I support it so much conceptually is that the current practice disincentivizes public service. That if you have people who are in the job market, and I know this from personal experience because I had a lot of my friends who didn't want to go take a job in public service because they were worried about it hurting their salary history trajectory. And so that when they were wanting to take the next job afterwards, they would be penalized by the system that we have because they would be making a lot less money than a colleague who had the exact same credentials, but who had decided to pursue a career and stay in a private sector job. Now, I got to say, all that being said, I find the arguments that have been made on the floor very convincing, and I think it's hard for us to tell the businesses of the state of California that they have to do this when we're not doing it fully ourselves here in the legislature. So I'm willing to vote for this bill, but I think we all have to examine our own practices, and if there are legitimate reasons why we shouldn't be doing it here in the Senate, then we have to be thinking about the fact that we're about to tell every business in California that they have to do this. So if there's a good reason why we're not doing it here fully, I want to hear about it so I can make that determination. Right now, I'm planning on voting for this bill because of my concerns about how how current practice disincentivizes public service. But we're an employer too, and we ought to be consistent when we're telling everyone else to follow certain rules.
Members, additional debate or discussion on this item. Senator Mitchell, would you like to close?
I would be happy to. Thank you very much, everyone, for the rich, hearty debate, and I couldn't agree with you more. I think it's appropriate that I'm floor jacking the bill today, in that I too was a victim of the California State Senate policy that's on the books today. As a young staffer 27 years ago, starting out in a district office, came in as probably a clerk typist too, as my grandmother would say, to get my foot in the door after my Coro Foundation fellowship. Literally, I had a senator who split a job in half, so it was working full-time, part-time salary. Had a promotional opportunity to come work in the Capitol. At 23, I jumped at the opportunity, and I was hit with the policy cap. I couldn't earn more than 5 or 10% more than I was making at that entry-level position to get in the door. I get it, I agree, and I certainly hope that our commitment to this issue extends beyond floor discussion, that we both go back, all of us go back to our caucuses and have a meaningful conversation within our caucus and within leadership about our desire to make a specific, concrete difference around pay equity in this House. We have the opportunity to do that. We have to act like the employers that we are, and I'll be standing right there with you as a living example. I beg to differ with my colleague from the Inland Empire. As a former employer myself, as a CEO of a nonprofit organization with 500 employees, I use salary surveys on a regular basis to look across sector, to compare ourselves and the work my staff employees did to both private sector and public sector. Are there different job descriptions? Absolutely. But I think it is a common practice among all kinds of employers to really get a sense of the landscape so you can be competitive, so you can attract the best and brightest to your organization, to your industry. So salary surveys are readily available in the nonprofit sector, as well as the for-profit sector. You're required to do salary comparisons for your highly compensated employees. And that's not based on their prior salary. That's based on surveys across the board, across sectors, to really make sure that fair pay is being issued at the top end. We're now talking about raising the floor. If we want to have a conversation about pay equity, we have to look across the board to make sure that women are fairly compensated based on their skill set and the job they are being hired to do. With that, I ask for your aye vote on AB 1017.
Thank you, Secretary. Please call the roll.
Allen? Aye. Anderson? No. Bates? No. Bell? Aye. Berryhill? No. Block? Aye. Canella? De Leon? Fuller? Gaines? No. Galgiani? Glazer? Hall? Aye. Hancock? Hernandez? Hertzberg? Hill? Aye. Hueso? Aye. Huff? No. Jackson? Aye. Lada? Aye. Leno? Aye. Leva? Aye. Liu? Aye. McGuire? Aye. Mendoza? Aye. Mitchell? Monning? Aye. Morlock? No. Morrell? No. Wynn? No. Nielsen? No. Pan? Aye. Pavley? Aye. Roth? Aye. Runner? No. Stone? No. Vidak? No. Wachowski? Aye. Wolk? Wolk, aye.
Call the absent members.
Canella? No. De Leon? Fuller? No. Galgiani? Glazer? Hancock? Aye. Hernandez? Aye. Hertzberg? Mitchell? Aye.
Ayes 22, noes 14. The measure passes.